And this is the worst way to be told no, Even worse than madam amesema nisikuwa na kufungulia. Even Google gives you reasons. Even Uber tells you your ride was cancelled. Here, it was just vibes. Ladies and gentlemen, boys and girls, welcome to another episode of Katiba na Chai, the show where we talk about the law, the constitution, and the kind of problems that only appear once you've already parked at a random gate. I'll explain why. Now, if you've heard about today's case on Twitter, you probably think it was about race, class, or rich people fighting rich people. And to be fair, that's not stupid. It's just that Kenyan Twitter doesn't need facts. It just needs vibes, a screenshot, and that one random guy who starts the thread with, "Let me explain." Okay, that's often me, but okay, now. But this case is actually about something a bit smaller, but much more dangerous. A decision that was made quietly at a gate without reasons. And Kenya's constitution does not like that. So this case involves Muthaiga Golf Club, one of those places where silence is part of the dress code. And before anyone panics, no. Listen, Katiba na Chai is not talking about golf today. Golf is innocent. I mean, we all know golf is cool for rich people. I mean, it's the same concept, a big stick, put balls into holes. I mean, and then you celebrate quietly. The only difference is that in pool you stop at 8. In golf, you keep going until someone inherits the course. So golf is basically Bano, but with land, silence, and unresolved childhood issues. Now, to understand why this case mattered, you need context, okay? Now, country clubs in Kenya didn't start as leisure spaces. No. They were sorting systems. In the colonial era, these were spaces for Europeans only. Africans were not even allowed to be excluded. There were stuff, decorations on the walls, now. After independence, of course, those signs came down, the law changed, membership diversified, there was progress, But one thing never fully left: discretion, okay? Country clubs are places where rules are not explained. They just felt, you just walk in and know, I don't belong. When people say, no problem, what they mean is a decision has been made. It's old status power. It's quiet power. The kind of power that does not need emails. Now, fast forward to modern Kenya, we have a new elite class of people. Professional success, They want public visibility, they want media presence, they have legal literacy. So when old money whispers, this new money starts a podcast. The irony. Now, old status doesn't explain itself. New money sends a thread, Old money hates two things: explanations and timestamps. New money believes if it happened, it should be documented, screenshotted, archived. And that's where today's guy, Donald B Kipkorir, comes in. Now, if you don't know, he's an advocate of the High Court, very successful, very public, and is very comfortable demanding reasons, okay? Kipkorir represents a certain modern Kenyan elite, a status which has been earned through achievement, not inheritance. How do I explain this? Think of it like this. He's a loud neighbor who moved to a very quiet neighborhood, And not because he forced his way in. No. He can afford the house. Shida. He pays the service charge. He doesn't whisper. Shida, And quiet neighborhoods don't hate noise because it's wrong. No. They hate it because it's visible, So, here's what actually happened. On 9th August 2024, our friend Donald is invited by a member of the club to come in and take legal instructions, And this is important because he wasn't sneaking in. He wasn't trespassing, He wasn't even that he applying for membership. No. He has been invited by a member. You see, country club invitations work differently. It's like a letter from Hogwarts. You can be brilliant. You can be accomplished. You can even afford the uniform. But without that letter, you're still a muggle. Or in Kenyan terms, mi na wewe. Bado we ni kienyo, bro. Now, he drives there, parks his car, walks up to the gate, and he gets turned away. No explanation, no reasons, no, let me confirm, just in case your name is, no. Just no. And this entire constitutional case happened at a gate because of that incident. Now, not at Parliament, not at State House, it was a gate. So the constitution was not violated in a boardroom. It was violated at the gate. And this is the worst way to be told no. Even worse than madam amesema nisikuwa na kufungulia. I mean, even Google gives you reasons. Even Uber tells you your ride was cancelled. Here, it was just vibes. And after this moment, the U-turn, the confusion, the silence, Donald does the predictable thing someone like him would do. He goes to court. Yes, I know. Even lawyers need lawyers, okay, when they go to court. Especially when the problem is other people's silence. So he files petition number E455 of 2024 in the High Court. And here's my favorite part. He does not just sue the club. My guy, he sues everyone. I looked at it. 18 respondents. 18. It was not just a lawsuit, Nani versus Nani. No. It was a class list. Hata huyu. You read the heading and you start wondering whether this is a constitutional petition or the credits of a movie. So the matter lands before Justice E C Mwita. And you can tell from the judgment that Justice Mwita is doing that very judicial thing of saying, all right, everyone, slow down. Tell me. Because the court is not hearing one story. It's hearing two completely different versions of reality. So let's start with what Donald Kipkorir tells the court. He says, and I'm quoting directly from the judgment here, by the way, on 9th August 2024, the petitioner, Donald, was invited by a client and a member of the club. So the petitioner went to the club, but when he got there, he was denied entry and was not even told why. There was no reason given. He tells the court this was not new. The incident had followed another that had occurred in October 2022. He remembers when the petitioner was first denied entry, but later was allowed after he complained. Alikumbuka, he wrote. He explains that for over 20 years, he had attended meetings at the club on invitation without incident. Then he explains the real harm. It was not that he was inconvenienced. It was not transport. It was his reputation. The judgment records him saying, the refusal to grant him entry to the club portrays him badly as a public nuisance in the eyes of other clients and other members of the club. And that line matters. It's not about golf. It's about standing. And it makes one thing very clear. He is not a member of the club and does not wish to be a member. Anyway, this was never about joining Muthaiga. It was about being publicly turned away after being invited. Ujua ninyi mmenita hapa. Na natafanya kitu hapa mshagae. Now, the club responds, and Muthaiga Country Club tells the court, the club is for private members and access is limited to members. They invited guests and members of reciprocating clubs. And which is fair. They also say Kipkorir knew why he was being denied entry. And then they add this, and I quote, the respondents, that's the club, have no record that the petitioner visited the club on that day, but was turned away. Wamesikia leo. At this point, Justice Mwita is probably adjusting his glasses because in the same affidavit, the club also admits the petitioner was invited to the club on 9th August 2024 at 9:45 a.m. But at 10:25 a.m., a member was informed that the petitioner is not allowed into the club as a guest. Pause. They are saying he didn't come, but they also say they told the host he wasn't allowed. Now, and this was after the invitation had already been sent. See? So Justice Mwita calmly writes, that in itself is an admission that the petitioner was not excluded from the club at the time of invitation. This is like a quiet knockout. Majembe, challenge. If at all the host was aware when inviting the petitioner that the petitioner would not be allowed to the club, there would have been no reason to invite him in the first place. Hapa ni drama too. No drama, just logic. Now, this is where the constitutional enters. Here we talk about rights. Article 47 says, every person has a right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. The same article says that if a right or a fundamental freedom of a person has been or is likely to be adversely affected, the person has the right to be given written reasons. Now, Article 47 is basically HR for power and law. Now, it says it's like you cannot fire someone by vibes. You cannot discipline someone by silence, And Justice Mwita even acknowledges, and I quote, it is true that a private club has the right of admission, but then he draws the line. However, the respondents, that's the club, like everybody else, are bound by constitutional principles to respect, uphold, and defend the Constitution. And remember, Article 20 of the Constitution says, the Bill of Rights applies to all law and binds all state organs and all persons. Not just government, not just police, everyone, you and me included. On dignity, the Constitution says, every person has the inherent dignity and the right to have the dignity respected and protected. And as Justice Mwita concludes, the respondent's action, that's the club's action, violated Donald's right to fair administrative action. And further, the respondent's action failed to respect the petitioner's right to human dignity, but humiliated him. Kuweka mtu kwa gate mwambie mbona afukuzwa kama mbwa. Okay. Importantly, the court rejects the discrimination claim that this was not about race. He had tried to make it about race. It was about process. And the court does not overreach. So, no forced entry, no membership, no locker, no tea time. But there was compensation. The court awarded Donald 1 million shillings. So, the court didn't give him a key to the club, but it sent a bill to the club. And that's the lesson. You can still own the gate. You can still decide who enters, but you can't embarrass people quietly anymore. You know? So this is the constitutional version of, imagine it's not me, it's you. Yeah, you have to explain. You can't just do that. Except that they didn't even say that. They just said nothing. And silence, as Justice Mwita politely reminded everyone, is not a strategy. So, no, this case didn't open the gates of Muthaiga Golf Club. It just closed the loophole. If this episode has helped you see how power really works in Kenya, not loudly but quietly, share it with someone who still thinks the Constitution lives in courtrooms. Don't forget to subscribe to Katiba na Chai, because the law isn't just about what's written, it's about what people think they can get away with. And apparently, even golf clubs are learning that now. Until next time, see you on Katiba na Chai.